The Supreme Court didn't take the case, so the law must be constitutional. If I had $1 for every time I heard that, I could probably fund my own legal challenges. That statement is wrong, like legally wrong. Today we're breaking down how gun laws actually die. Not in Congress, not on Twitter, and usually not in the Supreme Court. If you ever wondered why courts block gun laws, then unblock them, why states keep passing laws that they already lost, why everything seems to take years, why you keep hearing 2 more weeks like it's a bad military deployment. This episode is for you. This is Trigger Happy Tactical Podcast. Lock, load, and listen, because today we're walking the entire court pipeline. All right, first off, I'd like to shout out a friend of the podcast, Dave, you know who you are, for asking me to make this episode. I believe his words exactly were something along the lines of, can you make an episode explaining the fucking court systems? Well, here you go, Dave. This one's for you, buddy. All right, so let's start talking about the pipeline. And this one we want to burn into our brain, right? Here is the system in what I would call human terms. We start off with a gun law being passed. Someone then has standing issue, can sue. A district court then rules, injunctions and stays create utter chaos, appeals courts decide most of those outcomes, en banc games begin, the Supreme Court maybe steps in. Now, before we talk about California, New York, Illinois, or any specific cases, we need to slow down just a bit and explain how the court systems actually work, because this is where most of you get lost. Honestly, me too. Now, I am by no means a professional, and I'm not a lawyer when it comes to this sort of stuff. I just know a hell of a lot about it and kind of put together something for you so that hopefully everybody kind of understands how this goes when we read about it. So let's talk about the court ladder, how gun laws move kind of through the pseudo system here. And you need to think of the court system like a ladder. This isn't an elevator. You don't just simply press a button and jump to the top. You climb slowly, and sometimes you even slide back down a rung or two. Here's the basic ladder for federal gun law cases. Step 1 is the district court. This is what we would call ground floor. Every federal gun case starts right here. You got one judge, one courtroom. This is where lawsuits are filed. The judge hears the evidence, reviews history, applies Supreme Court precedents, and decides whether the law likely violates the Constitution. This is also where we see injunctions, or the law being blocked, or denials and stays, where the law stays in effect. Think of district court as, is this law probably illegal? Not, is this final answer forever? It's not the way it goes. This isn't set in stone. Step 2 is our 3-judge appeals panel, and this kind of is like the first review. If someone loses in district court, they'll definitely appeal. The appeals go to the federal circuit court where 3 judges review the case. There's no new evidence most of the time, no new witnesses most of the time. It's just legal arguments. These judges will ask, did the district court apply the law correctly? Most gun laws that die usually just die right here. This is probably one of the most important rungs of the ladder. The next step is the en banc review. This is sort of the reset button, I guess is the best way to call this. If a state loses at the appeals panel level, it may ask for an en banc review. This means a rehearing by more judges in the same district. There are 2 versions to this most of the time, and that kind of matters a lot. There's a full en banc panel where all active judges in that circuit will come onto it. It's a little bit more rare, it's a little bit more expensive, and it's kind of a big deal. Then there's a limited en banc panel, like we see in the 9th Circuit weirdness, whatever they got going on. This is still only 3 judges, and they're randomly selected. And it's still called an en banc panel, even though, well, it's really not. This is how outcomes get flipped without the full court weighing in. This step exists mainly to delay final outcomes, maintain ideological control, and avoid admitting previous courts were wrong. The next step is going to be the Supreme Court. This is the final boss. After all of that, a case may reach the Supreme Court. Important word that I just said there is may. It may reach the Supreme Court because realistically speaking, the Supreme Court only takes about 1% of its cases. It's not required to fix every bad ruling, and it usually will wait for the lower courts to finish fighting it out. When the Supreme Court of the United States, or SCOTUS, denies the case, it does not mean the law is constitutional. The lower court was correct. It usually means finish the process in the state level. What the Supreme Court actually does and what it doesn't do is this. Before we go any further, we want to clear up one of the biggest misunderstandings in America. The Supreme Court does not pass laws. It does not write policy. It does not care if something is popular. And it definitely doesn't fix things the way Congress should. The Supreme Court has one primary objective or job: to decide whether a law is considered constitutional. That's it. That's all their job is. They don't ask, is this a good idea? Does this make people feel safer? And will this poll well for us? They simply ask, does this violate the Constitution or not? If the answer is yes, then the law dies. If the answer is no, the law survives, even if it's fucking dumb. What the Supreme Court isn't, though, is it's not a legislator. It's not a regulatory agency. It's not a public safety board or a moral referee. They don't rewrite bad laws or offer compromises or draft replacement policies of any kind. When the court strikes down a gun law, they don't say, here's how you should regulate guns. They say, this crosses a constitutional line. And then they're done. That's their job. Now, why this confuses people, and trust me, politicians love the confusion here, because most people think if the Supreme Court rules something unconstitutional, they should also tell us what to do next. No, that's Congress's job. And Congress hates that job. So when a gun law gets struck down, politicians often respond with stupid-ass phrases like, the court is legislating from the bench, or the court is being activist, or the court is endangering the public's safety. However, none of that is true. It's all rhetoric and bullshit. What the court is really saying is, you passed a law you were never allowed to pass in the first place. This isn't activism. This is enforcement. Now, how does this actually apply to gun-specific cases? When the Supreme Court decides a Second Amendment case, they're not saying this is the perfect gun policy, or here's the perfect gun policy, here's how many rounds is okay and acceptable, and here's where you can or can't carry. What they're saying is, this violates the Second Amendment. This does not align with the text, history, and tradition, and this exceeds constitutional authority. Everything after that, rewrites, new bills, replacement schemes, that's on the states. Now, let's jump back into the pipeline itself. So, and keep this in mind as we move forward. The Supreme Court doesn't make gun laws, as we said. They don't make gun bans. They don't ban guns themselves, and they don't regulate guns. They simply draw the constitutional line and tell lawmakers when they've crossed that line. So here's an important reality check. A law can be challenged, ruled unconstitutional, upheld temporarily, blocked, reinstated, sent back, and rewritten all at the same exact time, depending on where it is in this ladder. That's why headlines are utterly useless unless you know which rung you're on. All right, now that you understand the whole ladder thing, now the timelines make a little bit more sense to you, and now the chaos has a structure to it. And now we can talk about how states abuse this system on purpose. Let's talk about step one. Gun law is passed. This is our reality check. States like California, New York, and our great state, Illinois, pass gun laws knowing full well they'll be challenged. Why do they do that? Because enforcement starts immediately, and lawsuits don't. So they pass it knowing that we'll immediately start to enforce it, and we'll just buy ourselves some time until those lawsuits actually start. An unconstitutional law can still ruin lives for years before a court decides to kill it. That's not incompetence, that's pure strategy. Step 2 would be the standing. Who can actually sue? Courts don't care how angry you are. They care if you're directly affected, you face real enforcement, or you can prove some sort of harm. And this is usually why lawsuits come from people like gun owners, gun stores, firearms manufacturers, and firearms right organizations. No standing equals case tossed out before it even loads its mags. Step 3 would be the district court, where the fight starts to begin. A federal district judge hears the case. This is where evidence is now introduced, history is argued, experts will testify. Bruin is supposed to be applied here. Sometimes judges do their job. Sometimes they slow walk, like they're getting paid by the hour. And that's because they are getting paid by the hour on this one. Step 4 is going to be injunctions and stays. This is why the headlines kind of lie. An injunction, the judge says, this law is likely unconstitutional. It is now blocked. Us gun owners, we celebrate. Ticker tape flies from the sky. A stay, however, states immediately will ask, can we pause that while we appeal? If that's granted, the law then goes back into effect while the case continues on. So yes, a law can be ruled unconstitutional and still enforced. Welcome to procedural hell. Now, let's talk about a couple of states for real. Here's a real timeline. California's mag ban. Year 0 on this one. Magazine ban passes. It became enforced. Year 1, district court. Judge rules magazines are arms, commonly owned, and there is no historical ban. An injunction is then issued and freedom briefly exists. However, months later, they have a stay. The state appeals, the stay is then granted, and the ban returns. But then we jump to year 2, and a 3-judge appeals panel jumps in, and the panel rules this ban is unconstitutional. But then here comes year 3, where we have a limited en banc panel. 3-judge panel, outcome then gets flipped, and the ban is instantly reinstated. Year 4 and 5, the Supreme Court ping-pong at this point. It's been vacated, remand, rinse and repeat. Now let's jump on New York and their sensitive places. Well, Bruin was decided. New York responds by declaring everything now a sensitive area. The district court then blocks it. A stay is then issued. The law returns. Appeals court drags its feet, and the Supreme Court simply sits back and watches for it to be done. The next one is going to be our great state here of Illinois. Illinois' assault weapons ban, or as we also call the Protect Illinois Communities ban, because it's just really protecting everybody. Law passed, immediate enforcement, conflicting district rulings. Then we get temporary injunctions, then instantly becomes temporary stays. And then an appeals court now consolidates everything into one, and Illinois is just stuck in holding pattern hell. Now, the fake en banc problem is this. Limited en banc panels exist. They flip outcomes, they delay finality, and they're legal and they are also abused. And why does this take years? Because time is punishment. Delay is the weapon. Why you keep hearing things like, oh, just 2 more weeks. And that's because courts move at government speed, at political comfort speed, at don't rock the boat speed. 2 weeks means 2 months or 2 years, realistically. So why does the Supreme Court allow the lower courts to screw this one up? And that's because it's not their job to keep track of this. They're not babysitters to all the rulings going on around a country, and they only step in when that system breaks publicly and it reaches that point. Because most of the time, it has to be finished at the state level before the Supreme Court will even touch this with a 10-foot pole. So that's all fine and dandy, but how do we actually fight back, and how do we fight back the right way? Well, 1, support real litigation. Jump onto some of these lawsuits. File witness slips where they're applicable in the states where we have witness slips. And stop doing dumb shit. Listen, being boring is the tactical standpoint on this one, right? Be smart. Don't allow them to use things that you do against us. And how do we explain this whole procedure to non-gun people? It's simple. A law can be unconstitutional and still enforced until courts finish reviewing it. Courts move slowly to avoid chaos, not because the law is good. That's it. That's where we end that. All right, well, gun laws don't die loudly. They die slowly, quietly, and deliberately. If you understand the pipeline, you stop panicking. You stop falling for all that clickbait bullshit, and you start to see the long game. Well, this is Trigger Happy Tactical Podcast. Lock, load, and listen, because knowing how the system works is how you protect your rights. I'll see y'all next time. And don't forget to check out triggerhappytactical.com for cool Trigger Happy Tactical merch all over that store. And if you got a little bit more free time, jump on D5 Ranges Marengo's YouTube to check out other cool content that I'm in. And, you want to see a little bit more of me, because we're friends like that. All right, until next time, I'll see you then.